Morning everybody and welcome to June's Employment Coffee Briefing, a week later than usual because I was in Bath this time last week enjoying the sun, so to work, much happier to be here, of course I am. Today's session will run exactly the same as we always have done. We're a little over halfway now through this sort of life cycle that we're doing of the employee engagement over the 12 months from the end of last year into the end of this year. And of course we've started to move away now a little bit from maybe some of the technical issue stuff that arises. It makes a nice change to move away from things like performance and discipline and do today's session on family-friendly rights and the various entitlements that are associated with those. As always, this session is being recorded. It will be made available. I've got a Q&A box. I've got a chat function in front of me, so by all means, please make use of them as always. This will be quite a useful one, I think, maybe for sharing views, experiences that people may have had of implementing some of these rights. I'm sure there'll be questions that crop up later. I will try my best to answer those, but there are some confusing technical points. As I say, I'm on a slightly different system today, so I'm making use of, you probably noticed, not my headset. So if there are any issues with sound or people hearing me properly, please do give me a shout as well. Without further ado, then, the next sort of half hour or so on family-friendly rights and the various entitlements. Actually works, there we go. So there we are, they're sort of the big main ones that occurred to me as I was preparing this session. We've got paternity leave and pay, adoption leave and pay, the right to time off for neonatal care, shared parental leave, time off for dependents, maternity, carers leave, flexible and predictable working I'll cover in there as well, and parental bereavement leave. These are, in terms of what I'm covering today, really all sort of the basic statutory entitlements that exist. Obviously, your individual organisations that you either work in or with may have their own versions, may have separate contractual entitlements, may have different forms of paid leave that people are entitled to take for family-friendly or other reasons. I'll be focusing, as I say, primarily on the statutory entitlements as we work through these, so it will be a little bit of a whistle-stop tour of the existing rights and entitlements, just as a reminder of what's already out there for everybody. There are some changes that have occurred, particularly this year and rolling into next year. We've touched on them in some of the sessions that my team have done together, but we'll look at them again briefly here. And as always, all the way through, the real purpose of these sessions is to highlight the things to be aware of as and when they flag up. This isn't necessarily about making everybody an expert on how shared parental leave works, but if we can raise some of the red flags, know when there's an issue, know when there's a query, then I always think that is quite helpful. As I say, please do shout questions, stick something in the chat if you have any queries as we go through. But this will be a slightly more talking-based one than perhaps engagement as previously. So, maternity leave and maternity pay, probably the one that most of us will be most familiar with. A lot of people on this call will have taken maternity leave, been on maternity leave and pay, been the partner of somebody who is on maternity leave and pay, and I suspect most of us are probably the result of somebody who's been on maternity leave at some point. Current UK statutory entitlement then, just as a reminder, ordinary maternity leave of up to 26 weeks and additional maternity leave of a further 26 weeks, allowing for up to a year in total. Earliest time it generally starts, as people will probably be aware, about 11 weeks before the expected week of childbirth. I've just had somebody say that they're having an issue with the sound quality. Is everybody struggling with that? Not super clear I can hear. All right, let me see if I can make any quick changes to it. Right, switching to a different microphone. Is that any better for anybody? There we go. No idea what I did there, but I'll have to sort of just press that button more often and see what happens. So just skipping back quickly, ordinary maternity leave then 26 weeks, additional maternity leave 26 weeks, giving us a year's leave entitlement in total. Usual start date, as I say there, 11 weeks before the expected week of childbirth, usually the earliest it kicks in. If not, and if not arranged or organised differently or notified to the employer separately, as we'll come on to, maternity leave will start the day after the birth actually takes place, or will be triggered automatically if the employee is off for any pregnancy-related illness in the 4 weeks prior to the expected due dates. The 2 weeks immediately after the birth are, of course, mandatory, and don't forget, with maternity and pregnancy, there are additional expectations on you if you work in a sector where there might be a risk to the child or the mother on return. So we're thinking sort of various health and safety risk assessment, particularly in sectors that involve heavy work or certain chemical work. Statutory pay entitlement, we're going to become very familiar with these figures because they are the statutory entitlement for pretty much all forms of leave. 90% of average weekly earnings for the first 6 weeks of leave, followed by the statutory rates, currently £184.03, or 90% of their pay, whichever is the lower. They get that for the following 33 weeks. As I said previously, many businesses will have some form of enhanced pay during that period as well. It might be that they get 90%, drop down to 50 for the following few months. It's not an unusual pattern. Some larger businesses, and if you are encountering particularly public sector, schools, NHS, etc., we know they have fairly generous maternity, sick, and various other forms of pay entitlements as well. Moving on, if you'll let me change, there we go. Eligibility criteria for these. So don't forget, the individual has to be an employee technically to be entitled to what is actually statutory maternity leave. It's a worker earning above minimum wage threshold, sorry, national insurance threshold, get my words out, for pay. Correct notice has to be given, and again, as people will be familiar with, that's usually 15 weeks before the due date to confirm their leave, 28 days notice in order to be entitled to pay. In practice, again, as many people will be familiar with, it's usually done on the MAP B1 form, which a healthcare professional will tend to give somewhere around 20 weeks before the due date. If that is provided along with general notice of your intention, that is sufficient. That said, it doesn't have to be done in that way. It's a useful way, obviously, to prove the pregnancy and to prove the expected due date, but notification doesn't have to be in a MAP B1. We'll come on to some of the additional protections. I mentioned a couple of them a moment ago in relation to maternity and pregnancy shortly, but don't forget that specifically for maternity and pregnancy, we've got elements of the Equality Act that provide additional protections to parents, and the various other pregnancy regulations that are applicable as well. So as I mentioned a few moments ago, they're all the ones around health and safety, risk assessments for returning mothers, and in particular, I will come on to redundancy protections towards the end of the session. Broadly speaking as well, of course, we've got the right to return to work. That exists for most of the statutory entitlements. It's specifically in the maternity leave regulations. Individual is entitled to return to the same job if they have taken ordinary maternity leave the first 26 weeks only. If they take additional maternity leave, the expectation is that they will return on no less favourable terms. What that broadly means is that the job shouldn't be on a lower salary, it shouldn't be on worse working conditions, it shouldn't be a perceived demotion, and really things like the hours, the travel time, the commuting distance should all be comparable as well. Yes, to answer the question that's just popped up, I can circulate a copy of the slides, and as I say, the recording will feature them anyway. But yes, happy to circulate the slides, don't worry. Anything else on maternity leave or pay not allowing for redundancy protection that I'll come back to before I move on? No, good. Paternity then, slightly shorter entitlement. Obviously, because the purpose, or one of the purposes of maternity leave, is very much about the physical and psychological recovery as well, as much as the bonding with the baby, of course. Paternity leave, 1 or 2 weeks leave. This is one that has changed this year. Until the 6th of April, the position on this was that taking paternity leave, you simply have the choice immediately after birth. You can take 1 week or you can take 2 weeks in one go, use it or lose it. That has changed since the 6th of April this year, so any birth that is happening now, basically, we can choose to take 1 or 2 weeks leave that can be taken together or separately. Definition of a week is a normal working week. So as I've said there, somebody who works 0.4 full-time equivalent gets their 2 days. They don't get 2 lots of 5 days just because that's the normal definition of a week. The leave can't start before the birth, and it must be taken within the first year after the birth. There is a 28-day notice requirement. That said, as I said at the bottom there, the notice requirement doesn't have to be precise. So the employee does not have to be saying, I'm taking paternity leave from midday on Tuesday the 22nd. From the date of birth is sufficient because, of course, it can't start before the birth. And as we all know, apart from very, very particularly planned cases, it's quite hard to know exactly when the date and time of birth will be. What does somebody get if they're on paternity leave? Well, subject again to all of the eligibility requirements, they get the statutory weekly rate of paternity, 18403 currently, or 90% of their average weekly earnings, whichever is the lower. New point I've just added to the bottom of that, it is applicable to maternity. We'll see it crop up again in the other forms of leave as well. Somebody who is on paternity leave, if the circumstances change in their employment, so if pay rises are issued during the couple of weeks that they're off, they are still entitled to them. Their holiday continues to accrue while they're on paternity leave. It's a form of statutory leave. And they do have the right to return to work at the end of it as well. It's a potential discrimination claim. It's a potential breach of the regulations claim for not allowing them to do so. Not much more to say on paternity leave. It is only a couple of weeks, and it is basically a statutory entitlement. Most people now, as we'll come on to shortly, are making much more use of shared parental leave. Adoption leave and pay, of course, increasingly coming to the forefront now. Adoption rates are slowly improving and have done over the last few years. Much more similar in a sense to maternity entitlement here. So the adoption leave entitlement is for the primary adopter. There will always be somebody in an adoption who is considered the primary adopter, and it's them who gets this entitlement. And that entitlement to leave, as I say there, is, well, it pretty much mirrors maternity entitlements. The other eligibility is largely the same. 26 weeks ordinary leave, 26 weeks potential additional leave. The start date for that is slightly more flexible, I suppose, than it is for other forms of leave because of the bureaucracy around adoption entitlements. But generally, they're the 3 potential start dates for adoption leave. 14 days before the child starts living with the primary adopter, fine. That sort of mirrors maternity. A couple of weeks before the expected due date is fairly normal. If it's an overseas adoption, it's when the child arrives in the UK or allowing for that sort of bureaucratic process within 28 days of that date. It may well be that a parent doesn't want to take time off from the moment the child arrives in the UK if there's going to be, for example, a quarantine process, or there's going to be some bureaucratic reason why it takes another couple of weeks for them to actually have the child with them. Or if the adoption is following immediately from surrogacy, it's the day the child is born or the day after. Again, it's one of those situations where communication is going to be quite important so that we know exactly how the adoption is taking place, on what basis it is, and what the primary adopter actually wants in terms of their leave. Pay, again, guess what? 90% of average weekly earnings for the first 6 weeks, or the statutory rate, and the statutory rate for the following 33. Exactly the same entitlements and eligibility as maternity pay and leave. So again, must be an employee to technically get the leave entitlement, must give notice, and again, similarly, must have been employed for at least 26 weeks at that NI threshold for pay entitlement. That's that 1, 2, 3 a week figure that gets churned out occasionally in these settings. This is going to feel slightly repetitive, but any comments or queries about adoption leave or how that works? I'm assuming not, on the basis that it works very similarly to maternity leave and pay. No. Good. So, shared parental leave and pay. This is the one that
It's strange because it probably happens more than we think it does, but we don't seem to get very many questions about it. So I will be curious, just as I'm talking, if anybody wants to put in the Q&A or the chat box, whether they found people are actually making use of shared parental leave and whether they have any issues with how it's implemented. The purpose of shared parental leave, of course, is that any situation where parents are having a child, using a surrogate and adopting or fostering with a view to adopt, they do have the ability to share the majority of what would be that leave entitlement. So it's an entitlement to share up to 50 weeks of leave. The basic statutory entitlements to the other forms of maternity and adoption we know are 52, but there is that 2-week requirement for the mother to take those 2 immediate weeks. So that's where we get the 50 from. And to share 37 weeks of pay between them, depending on how they want to make use of this leave period. It does have to be used within the first year after birth or placement. And my current reading of this, because it's a question that's come up a couple of times for me in the last year or so, I believe it can be simultaneous with other forms of leave. Somebody can be on adoption leave while their partner is on shared parental leave, providing all of the various notice requirements have been done correctly. And we'll come on to this in a moment. To me, that makes sense. And I've had the question crop up about 6 months ago in relation to adoption leave. Logically, if we've got a mother on maternity leave and the father wants to take simultaneous shared parental leave, it would make sense to me that that's allowed. I can't see why it'd be any different in an adoption situation. So here's a few situations where this might happen, because eligibility can be a little bit messy under shared parental leave. So the adopter qualifies for adoption leave, but their earnings are too low for pay. The partner qualifies for paternity leave and statutory paternity pay. The adopter does get shared parental leave in that situation. As we know, they're already qualified, but they will not get shared parental pay. The partner is probably going to get shared parental leave and pay. So it could be a benefit here for them to make more use of shared parental leave in this situation, because they're much more likely to get a worthwhile payment. Agency workers can qualify for various forms of entitlement. Here's an agency worker who qualifies for adoption pay but not leave, and the partner who qualifies for paternity leave and paternity pay. Again, there is sort of some benefit here to the partner making more use of SPL, because they could end up being entitled to more statutory payments overall in this situation, because of the agency workers' sort of reduced entitlement to leave there. I had a question pop in. If an organisation offers full pay for 6 months for maternity leave and a father takes shared parental leave, should he also be entitled to full pay? Yeah, it's a discrimination question. It is an interesting one. There is case law on this that broadly says no. On the other hand, I think I probably disagree on kind of a moral and ethical ground. It's a slightly grey area because I think it could give rise to a reviewed case for sex discrimination. The case that actually arose in that situation was to do with enhanced maternity and paternity protections, and it was in the public sector. It's the only case I'm aware of it, and it was deemed for various reasons to not be discriminatory. Funnily enough, part of the justification went back to something I said earlier about the reasons for maternity leave. And it was commented during that case that part of the reason for maternity leave is as much as I said about the physical and emotional recovery from giving birth, which of course is not quite as true for paternity or indeed shared parental leave. I do think it's ripe for litigation. I don't think there's one happening anytime soon. But I think it's an interesting question, because you get a similar one in relation to do we give enhanced maternity, paternity, but not adoption? And then I think you've got a question as to whether there's an indirect sexual orientation discrimination claim there. Are adopters much more likely to be same-sex parents? I would suggest so. Is that a sex discrimination case? I think it's important to review enhanced benefits, because I think these things are increasingly going to start being tested, especially with the confusion around shared parental leave. Yeah, and I agree with the response that the person who asked that question has just said. Often see organisations enhancing maternity and adoption, but very rarely shared parental. And I think Again, it'd be interesting to see what people think about this, but I suppose the question is whether they're not doing that because shared parental isn't actually being used. I've got no idea what the statistics are because it's obviously not something that's easily calculable. Moving on then, let's have a look at a little bit of maths and a little bit of how this actually works. So this is a very, very basic example where I'll stuck a question on the screen. Feel free to start commenting. So let's say A is the primary adopter. She's entitled to full adoption leave and pay. The partner is also entitled to all of the various statutory entitlements. So let's assume they're both entitled to everything. He gets paternity leave and pay. He is also in principle eligible for shared parental leave. They want to take the first 2 months together off to look after a newly adopted child. Can they do this? Anybody got any immediate thoughts? So of course his paternity is only 2 weeks. He wants to make that 8, doesn't he, for the first 2 months, presumably by using shared parental leave. But one assumes while A is still on adoption leave. So I suppose my question is, can somebody still be on adoption leave while their partner is on shared parental? Handful of yeses coming in. Anybody think no? Until a few weeks ago I did. So it gives away the answer now. I mean, yes, in principle, they absolutely can do this. It draws back to what we were saying earlier. If we think about it from a maternity point of view, absolutely no reason why we wouldn't want the 2 parents to be able to be off at the same time. The purpose of shared parental leave isn't necessarily to halve the overall entitlement between the parents. In a sense, the primary adopter is still entitled to their adoption leave. The birth mother is still entitled to maternity leave. The fact that they choose to surrender some of that. I'm just going to have to wave around the room now, aren't I? There you go, have a brief blackout. I know it was a boring topic, I didn't realise it was that boring. Yes, and I mean, they're still entitled to the primary form of leave that exists here. We're giving up some of their leave to transfer it for shared parental. They're not losing their entire entitlement. The idea is that what they give up shifts or transfers to the other partner. It's not necessarily the case that they're surrendering their entire entitlement. So here's the situation. Let's think about maybe how they do this a little bit and how it actually looks in practice. It's still exactly the same scenario. Would anybody actually know how this works other than the 2 people who I now know how this works because we've talked about it recently? I realise I'm giving you quite a long answer to have to give here. I suppose my answer is actually maybe don't answer how do they do this, but if you were advising the individual, would you know how to tell them how to do it is maybe a better question. Or if an organisation wanted your advice on how it works. Yeah, few people putting pretty good educated guesses. I've got a couple of things, though. There's a couple of I haven't got a clues, which is fair enough. It's not something that crops up very often. So this is how it works. A, who is our primary adopter, has to give notice to her employer that she's intending to reduce her adoption leave and pay by the 6 weeks, which of course will then give the partner the additional 6 weeks he needs. This, as I say there, creates the 6 weeks of shared parental leave and pay for the partner to take. So he will take his 2 weeks of paternity immediately after the adoption takes place, and then has the 6 weeks that has been given to him by the primary adopter. Both parents have to give their respective employers at least 8 weeks notice of this before the start of his shared parental leave. So we're ignoring the notice for adoption leave, that will already have happened. We're ignoring the notice for his paternity leave because we already know that from the previous slides, that's not particular, it's 28 days. We're now talking 8 weeks for SPL because there is an administrative process that takes place here. Now, the really good news that I can give you, and again, as we've discovered, or I've discovered quite recently, is there is quite a good online government calculator for this. It is targeted at the parents. I'll just skim through very quickly. We'll jump to that first. It's targeted at the parents, and what they can do is fill in the dates that they're expecting to adopt, the dates that they maybe want to take as leave, the arrangements that they want to do. What will happen is they'll end up with this page that's in front of us now, which to us as employers and HR professionals is not going to be very useful. But you'll see at the top of that page, there's a thing that says you can answer some additional questions. If you go through that process and start putting in the dates of what these two parents would like to do, you will actually get an incredibly useful table at the end that breaks down the dates that they're on various forms of leave and the payments they're entitled to. It does in fact go a step beyond this. You can even put in their exact salaries and it will tell you at what point it's 90% and what that calculation will be. I had not seen this for a very, very long time until it cropped up in a query that I had about shared parental leave, rediscovered it a few days ago and suddenly realised that it seems to do exactly what I think it should. Whether or not you trust government online calculators to be entirely accurate as to what the law is or not is of course up to you. It produced the result that I was expecting it to, so I'm reasonably satisfied with it. So if this does crop up, by all means use it, even if just as a guide to then go and get separate advice on. As I say, I actually think it's quite good. I've run it a couple of times with different outcomes based on different data being put in, and I think it does roughly what I would expect it to. Easiest way to find that, just whack in planned shared parental leave into Google. Other search engines are available. So jumping back, we've done the notice entitlement, we've done sort of how this works. What they then get, well, there we go. So assume it's a UK adoption that takes place on the 1st of August. The primary adopter's leave starts at the beginning of that week, the 29th of July. She gets her 46 weeks, 52 minus the 6 that we've, or the 2 and the separate 4, I suppose, that we've surrendered, and therefore ends on the 15th of June. His paternity is going to start on the 29th of July, the start of the placement week, finishes on the 12th of August. The 6 weeks additional shared parental leave that we've transferred takes him to the end of the week commencing the 22nd of September. It is very, very simply, she has knocked X number of weeks off the end of her adoption leave entitlement and granted it to him to take immediately following his period of paternity. And as far as I can figure out, that is absolutely fine. In terms of pay then, and again, this is exactly what the online calculator will produce for you in a lovely table. The adopter is going to get the initial 4 weeks at 90%. The partner will also get 4 weeks statutory, as we know. The adopter will then get the remaining 2 weeks at 90% salary. That's the 6 weeks in total at 90% before moving on to statutory entitlement. The partner is going to be unpaid after the end of the paternity period, plus the time that he is then taking as shared parental leave. But again, if there's a calculator there that does it for you, use it. If you're not sure about the outcome, take advice at that point. I think it worked quite well. It is a complicated one. Unless anybody had anything they sort of wanted to add in terms of experience of this, because again, I still don't know how much shared parental leave is being used, because I think if we struggle to understand it, I don't think a huge number of employees and workers are really understanding it or how it works, unless they make the conscious effort to look into it. If anybody does have a particular experience at their workplace where somebody has used it or it gets used a lot in your workplace, by all means, give us your thoughts, and I'm happy to share them with everyone. Otherwise, moving on from shared parental leave and how complicated it is, I did say this was just a whistle stop tour. We'll start talking about other things. So, changing entirely to flexible and predictable working patterns. So just pausing very quickly, I've had one question: how is shared parental leave traceable where parents work at different employers? Yep, I forgot to mention this and probably should have done. In the notification requirements, there is actually an incredibly useful form that's available on the government website. It's also available through ACAS that will guide you through the forms they need to fill in. And I think there's 4 on there that basically say, this is what I'm intending to do, this is what we'd like to do, I'm the primary adopter, and this is what my partner's intending to do. The primary adopters, or in a case of birth, maternity employer will sort of take lead on this potentially. There is one of those forms that is then passable to the other partner's employer so that they're aware of what's going on. And in effect, it's a signed declaration that is, we're doing this, we're planning to do that. Please, facilitate accordingly and make sure that your payroll are doing the right thing. And in effect, they've made that declaration at that point. just so you're aware, where the primary adopter or the mother in a maternity situation is giving up some of her maternity or adoption leave, or his adoption leave if he's a primary carer, that is very, very, very difficult to revoke. So once they've given you that notice that they're intending to do it, it's quite difficult for them to backtrack. Very, very extreme situations where that can happen. It's not just because they changed their mind. Shared parental leave adoption in the example 40. Yes, I may have got my maths wrong and confused on those slides. I'll double check them before they go out. Apologies. Thank you, Donna, for picking that up. So flexible and predictable working. This changed on the 6th of April this year. So flexible working requests have been in the news a little bit over the last year or so. A few cases around them, particularly stemming around sort of sex discrimination and disability discrimination. But a few changes now to how they're implemented and how they're done. So flexible changes, flexible working requests are now a day one right. Not entirely sure why. My suggestion would be that if you are getting a flexible working request on day one of employment, your recruitment process might need looking at. It's something that should be being discussed much earlier. If somebody's expecting flexible working or is wanting flexible working. Nothing more frustrating, I know, than somebody coming to an interview for a job that's clearly not flexible working and immediately requesting it. But the right is there now. In theory, an employee could make a flexible working request on day one of employment. It's now 2 requests within any 12-month period. It used to be 1. The employee must now be consulted with before a refusal, so it's no longer just a paperwork exercise. There needs to be some kind of conversation that goes on with the employee, particularly if you are going to refuse. The time between the request being made and an outcome has reduced to 2 months. It was 3. And there is a long list in the legislation of the way that employee has to do this. They have to make it clear that it's a flexible working request, set out what they're intending, explain how it will work. Part of that used to be explain to the employer the impact their proposal would have on the business, which to all intents and purposes was the employee having to explain to us why it wouldn't work. That has now been removed for what seems fairly obvious reasons. There is an ACAS code of practice on this that it is expected will form best practice, will be expected to be followed. If you haven't had a look at that yet and routinely deal with flexible working requests, then do have a look at it, particularly if you've got people who are dealing with them historically but maybe aren't aware of the changes since the 6th of April. Just had a question pop in, 2 requests in 12 months, is this one every 6 months or can they be simultaneous? In theory, they could lodge it about different circumstances before the previous one had been dealt with. It's a rolling 12-month period though, they could make a new one almost immediately. Question, this means someone could accept and start in a full-time role, then request to go part-time. Practically, can we decline this? Yes, the reasons for declining have not changed. It's still that list of them that's basically, this would impact the business negatively, this would impact service negatively, etc., etc. Ultimately, that list boils down to we really don't want to, and there's usually a way of finding an excuse to deny a flexible or, I'll come on to predictable in a moment, a flexible working request. You've only just started with us and this didn't come up in interview and it was clear it was a full-time role, is probably going to be pretty good justification, but you're still going to have to go through the tick box exercise of explaining why and consulting with them now in exactly the same way you would have done for a longer term employee. The other thing obviously to be mindful of in flexible working requests is it may be care commitments or it may be disability related that they chose not to disclose during the interview process. And then you're going to have to be careful not to be discriminating against that individual if the flexible working request could be a reasonable adjustment, for example. Anything else on flexi before I touch on predictable? No, and I'm hoping that answers that question as well. So predictable working requests, the excitingly named Workers' Predictable Terms and Conditions Act 2023, likely to come into force later this year. Basically, it's a little bit of an attack on what is perceived as the abuse of 0 hours contracts and 0 hours working patterns. It creates a new right for workers to request more predictable working conditions. Slightly unclear as to exactly how this will look at the moment, but I suspect, and the regulations as they are at the moment strongly suggest that the conditions and circumstances around it will all look very similar to flexible working requests. I suppose what you're likely to get is somebody who is on maybe an X number of hours a week contract asking if they could be between the hours of 6 and 6, rather than necessarily spread out too much late at night and various reasons like that. That said, it could potentially go as far as wanting set hours or as close to set hours as possible, because for some reason there is a drive towards more predictable working. That said, I don't know if I'm entirely sure that this will be used a huge amount by workers. The vast majority of people who are on very flexible patterns, 0 hours patterns, are there because it also suits them, as we know. But the right is there, and I do think it's probably designed to, as I said at the start, attack businesses that are using 0 hours contracts in a more abusive way. You know, we've already had kind of that removing exclusivity provisions. This is now moving into what the actual work pattern looks like as well. Yeah, not a huge amount to say on that at the moment because it hasn't come in yet. It will be in later this year. There is guidance out there on it. Do again have a read through. Yes, it sits alongside flexi requests. So you could, in theory, have 2 flexi requests and 2 predictable working requests from the same employer in the same 12-month period. Absolutely nothing we can do about that. It's very, very annoying, but it could happen. Anything on flexi or predictable working? No, if I miss a question, I'll come back to it towards the end if we get time. So the last few versions of leave that I just want to touch on, so we're moving back into other forms now. Parental leave, the one that I think often gets overlooked because most of us as businesses just in certain situations allow people unpaid time off to deal with things. I don't think anybody really sort of thinks about it too much as statutory parental leave as such. So unpaid parental leave subject to various eligibility criteria. There is technically this entitlement to 18 weeks leave per child up to their 18th birthday. And I say that in the tone of voice I have because a lot of people are often surprised when you say that this right exists. In theory, somebody could have the week of their child's birthday off every year until they turn 18 if they wanted to do so, albeit unpaid. As I said there, it is limited to 4 weeks per child per year. The individual has to be an employee, has to have worked with you for more than a year in order to take it, and they must give you 21 days notice. That said, there are very limited options in which you can postpone this. It's actually quite hard to do. People don't voluntarily take unpaid leave very often, as we know, and I suspect that is also part of the reason why this is not shouted about more often. But I think it's important to be aware of. It is there. It does exist, and in theory you could have staff who want to make use of it. If it ever crops up and anybody wants to discuss the options to postpone, I won't go through them now because they're a little bit complicated. Please do reach out because in a sense it's quite an interesting academic area. Time off for dependents then, this is distinct from parental leave and distinct from various other forms. This is very much the emergency leave where something has happened. It is most commonly used for children. You know, my child's had an accident at school or they've been suspended or something. But it does, strictly speaking, extend to the spouse, partner, child, or anyone who could be said to be cared for by the employee. No limits as to how long it is. The statutory entitlement is unpaid. But again, let's not forget that most businesses do allow some form of flexibility or compassionate leave or whatever the case may be for various situations. They have to be an employee in order to exercise this leave, but there are no other sort of major requirements around eligibility for it because of its purpose, really. That said, as I've said at the bottom there, this isn't a right to take time off for things that were predictable or known in advance. It is very much an emergency entitlement. Like I say, it's a medical emergency. It's something's happened to the child at school. It's elderly parent has been rushed into hospital. It is not time off to take somebody to the dentist or go to a planned for medical appointment or anything like that. If people want to make use of that, it's parental leave, some other form of contractual paid leave, or worst case scenario for them, potentially annual Again, not much to say about that. I think most employers, in my experience, are reasonably flexible in these situations, and a lot of people aren't necessarily treating it as a statutory entitlement. I think a lot of us would say, you know, yes, if your child's been rushed into hospital from school, by all means go, and we'll deal with how that looks afterwards. One of the less fortunate ones that we have to talk about in these situations, parental bereavement leave. The UK was one of the first countries to introduce this and to give any form of entitlement whatsoever for this particular circumstance. Others have followed suit. I can't remember if New Zealand were just before or after us, but it's not really one of those where we want to be point scoring on an international scale. What exists here in parental bereavement leave is a statutory leave and pay entitlement if an employee's child dies before they turn 18 or the employee suffers a stillbirth after 24 weeks of pregnancy. Everything else we've sort of discussed in these situations continues to apply. It's the statutory pay rate. They have to be an employee in order to be entitled to leave, and they have to have 26 weeks service in order to get pay entitlements. Anything that happens, as I said, on maternity a while back, and it's applicable to all of them, anything that happens while somebody's on a form of statutory leave continues to tick over. So pay rises that take effect, bonus payments, the holiday accrues, they have the right to return. The leave entitlement is either 2 weeks to be taken, presumably immediately, 2 weeks separated, or just 1 week. And you'll see the entitlement there within 56 weeks of the death or the stillbirth. The reason I think that it's been allowed to roll on beyond that year is, of course, parents may want to take the first anniversary off as well if they're struggling around that time, and that's absolutely fine and permissible. Obviously, this is one of those situations where there's limited notice entitlement, and it's very much about how you communicate with the member of staff. I think they will probably not be aware of this. It would not be the first thing on their mind when they're going through one of these situations. So I do think it's one of those that should be signposted if you're ever unfortunate enough to be in a situation where you have a member of staff who has to go through this experience. Obviously, if businesses have got some other form of compassionate leave entitlement, that may be unpaid. So this is obviously better for them in the first instance. If there's a paid form of compassionate leave in the business, then naturally you'll be signposting to that anyway. The other one that is rolling in next year, arguably similarly distressing circumstances, neonatal care. So this, as I say, is intended to take effect from April 2025. So this is for employees who have got some kind of personal relationship with a baby who is in hospital receiving neonatal care. I say a personal relationship because it's not just parental. We're waiting for the full regulations to come through as to what exactly and who exactly will be included in those personal relationships, but I wouldn't be surprised if it extended to grandparents or partners of people with parental responsibility, for example. Neonatal care is not yet defined in the legislation. It's not entirely clear what that is going to mean. The leave entitlement will be between 1 and 12 weeks. Ultimately dependent on the care need. The intention is that it's for the time that the baby is actually receiving care in hospital. It will be a day one right for leave entitlement. Pay will be subject to having worked for 26 weeks. And we'll see that the leave is taken within 68 weeks of the birth. Not really much more to say on that. Again, it's one of those ones where there's not going to be a huge notice requirement. Employers are not going to be asking for a huge amount of evidence. I wouldn't have thought. There's no guarantee that an employee will be able to provide it anyway. So it'd be one of those balancing acts between making sure you're doing everything you need to do to keep your records as to what is going on and why, but while also simultaneously, obviously, being very aware of the emotional needs of the employee. I've had a question popping on parental bereavement leave, so I'll just jump back to this quickly. When this has happened, employee got a fit note. Are they entitled to this when fit note expires? Yes, basically is the short answer. The parental bereavement leave can be taken at any time within those 56 weeks after the death or the stillbirth. So if they're getting immediate fit note from a GP or hospital consultant, depending on the circumstances or whatever the case may be, saying that they're signed off for, say, 2 months, then yes, they take their sick pay. They're then more than entitled to take parental bereavement leave afterwards if they wish to do so. Equally, of course, it may well be that they decide to hang fire on the parental bereavement leave because they want the 2 weeks, 12 months later if they're obviously struggling around the first anniversary, which would be entirely understandable. Anything else on parental bereavement or neonatal care? No, right, very last one I want to touch on then, I think, who knows, this presentation could go on all day, why not? Redundancy protections for people who are on various forms of leave. So we're looking at, again, a couple of excitingly named bits of legislation: the Protection from Redundancy, Pregnancy and Family Leave Act, and the Maternity Leave, Adoption Leave and Shared Parental Leave Amendment regulations. We know this protection exists. The protected period for the redundancy situation for a returning mother from maternity leave, whoops, that'll teach me to lean on a clicker, won't it? Yeah, whatever, we'll come back to it in a minute. Oh, come on, wake up. Slowly roll my way back through that. Proof that I can't keep talking and manage a computer at the same time. So redundancy protections, there we go. We have that protected period when somebody returns from maternity leave. I'm getting bored of these lights as well. Remind me not to do a session in this room ever again. So we've got that period of protected leave. When a mother returns from maternity leave, we know that ultimately, as we said earlier, she is entitled to return to the same job or to a job on no less favourable terms. Similar protection for adoption leave. And in terms of redundancy situations, we know there's that additional protection that exists around a suitable alternative vacancy if it arises, being offered to somebody who is on maternity and in their pregnancy protected period. These regulations extend those protection periods. So in pregnancy, maternity and adoption situations, that period of protection commences the moment you're notified in ways we discussed earlier for maternity and adoption, and ends 18 months after birth or placement. It's quite a significant extension on that protected period to ensure that returning parents are not made redundant too easily, too shortly after they return. Miscarriage protection also been extended here. It starts from the notification of pregnancy and ends 2 weeks after the end of pregnancy if that's under 24 weeks. Shared parental leave is broken down slightly differently. If an employee takes less than 6 weeks shared parental leave, the protected period ends on the last day of that block of leave. If they take 6 weeks or more of continuous leave, the protected period ends 18 months from the date of the child's birth. The important thing to be aware of here, if somebody has recently come back from some period of statutory leave, whether that's maternity, adoption, shared parental, whatever the case may be, they are somewhat more protected in a redundancy situation. We're definitely not saying, just to answer the question, that they cannot be made redundant. Somebody who is on one of these leaves or recently has been, it can be made redundant if the redundancy is legitimate. The protection is around if a suitable alternative vacancy arises. The right is for them to, in effect, be offered the right of first refusal for that alternative role. And that's the extent of the protection here. So no, we're not saying that you cannot make somebody who has just come back from maternity leave redundant. That hasn't changed. If a redundancy is a legitimate redundancy, then it's a redundancy. Anything else on that? Because if not, I'm just about going to wrap up. So unless anybody's got any questions on anything, next session we're going to do a slight interlude. In case anybody hadn't noticed, we've got an election coming up next month. The next session is actually the day before the election. So I thought I would do a specific session on what a change in government, assuming we're going to have one, might mean for employment law. I will look at, it depends where we are in a month's time, really. I'll look at whichever party seems most likely to end up being in power and what they're intending to do, which, having read the Conservative manifesto yesterday, makes me hope it's not them, because I won't have anything to talk about. So that'll be the next session. That's on Wednesday, the 3rd of July. If anybody's got any questions on anything that I've talked about today, by all means, again, put them in the chat now. I can spend a couple of minutes looking at them. If not, please do email me or contact me some other way out of session. I'll help if I can. Otherwise, I hope everybody has a wonderful rest of their day. Enjoy June, and I'll see you in about 3-4 weeks' time.